Hi, I'm Erin Power.
And I'm Laura Rupsis.
We're certified health coaches, and this is Health Coach Radio.
This podcast is about the art, science, and business of health coaching.
We share our insider tips to help you become a better coach and entrepreneur.
And we interview expert guests to discover how they've made it in this growing field.
It's time for health coaches to make an impact.
It's time for Health Coach Radio.
This was a fun one, which is not something I ever thought I'd say about talking to a lawyer. Tania Shah and her partners Lisa Sigmund and Aaron Nobles have created In the Know Legal, a legal consulting company that teaches coaches on how to protect themselves personally and professionally with legal templates designed especially for the health coach getting started with their business. Essentially, Laura and I asked every single question that coaches ask us every single day about legal matters in building a health coaching practice, including disclaimers, terms and conditions, terms of use, which is different than terms and conditions, the client agreement, liability waivers, and more. Tania kept it light and funny and explained it in a way that's totally gettable, even for folks who aren't fluent in legalese. Our advice is to devour this episode at least twice and take good notes. We'd love to have you screenshot your podcast player and tag us on Instagram at Health Coach Radio. By the way, the show notes for this episode and all previous episodes of Health Coach Radio can be found at primalhealthcoach.com/radio. Enrollment is open for the fall semester of the Primal Health Coach Institute Level 2 certification course, an advanced coaching course that teaches you how to create transformational coach-client relationships. In our mind, the best way to grow your coaching practice. Not only will you learn and practice advanced coaching skills, but this course also satisfies the educational requirements to enable you to sit for the NBC HWC credentialing exam so you can become a board-certified health and wellness coach. Fun fact, PHCI has a 100% pass rate for the board exam. Every one of our graduates who've sat the board exam have passed it and become board certified. Stay tuned to the end of the show to learn more or visit primalhealthcoach.com/level2. With that out of the way, we'll get on with the show. We hope you'll enjoy this fun conversation with Tania Shah.
All right, Tania Shah, we're excited to talk to you, mostly because, at least I am, and I know Erin would be too, but I talk to people all day that have an interest in starting a business in this world. And one of the biggest questions we get is about scope of practice, liability, waivers, contracts, like all the legal stuff is just totally
Very.
Oh my gosh, terrifying. Yeah. So we would love you to add some clarity to all of this. But Absolutely. To start us off, please just tell us a little bit about give us like your 5-minute like origin story and how you landed here.
Sure, absolutely. So I started my first company about 20 years ago outside of law school, and it was actually a tutoring company for law students. So I realized I really loved to teach. I wanted to take a lot of the mystery out of law for students, probably how you take a lot of the mystery out of health. And that grew. And then because I was running my own business, something they don't teach you in law school, I started my own corporate practice to help small businesses and to really demystify this starting of a business. Because I really learned by myself. Remember when like Barnes and Nobles actually existed as a bookstore? I would go in and I couldn't afford to buy any books. So I would just read. I would like buy the coffee, like $1 coffee, and I would just sit there and read. Sometimes they felt sorry for me, so they would just give me the coffee. And so, I was there. And then so over the years, I was building my corporate sort of business legal practice. And, I've been loving it, and I continued teaching, and I started teaching at university and things like that. And one of the interesting things is that, sort of the first 2 decades was really spent those were kind of separate from each other, even though I definitely used, my teaching skills to talk to my entrepreneurs. Then, during the pandemic, and I know some people make pandemic babies, and this was our pandemic baby, myself and Lisa and Aaron, we said, we really need to figure out a way for entrepreneurs to teach them how to do things. Not only that, but do the stuff that comes before they have to go see a lawyer, right? So like health is, there's all these health things that are preventative, that you, I'm sure, deal with all the time and talk to people before they have to see a doctor. And a lot of times we go to a doctor and we don't know what it is that's going on, and we certainly leave and we have no idea what's going on after the 10 minutes they spend with us. So very similarly, we just wanted to figure out a more affordable way to educate our entrepreneurs, and with our first iteration, of course, being coaches, on how not only what they would need for their business, because that's always the first step. How are you supposed to know what they would need for the business, why they might need it, and how to implement it themselves, i.e. take that power, like one would take power over their health, to take the power over their business themselves, and also put a positive spin to it, right? There's a lot of negativity associated with lawyers, and sort of also if you go to a doctor, you go to a doctor only when something is wrong, and we really want to kind of take that negativity out of it and say, you can do a lot of this if you take this within yourselves to try and do this. So that's how we landed with In the Know Legal, which is sort of this combination of legal but it's not just a template company, but plus all the videos, walkthroughs, instructions that take you through each and every aspect of it.
Could you repeat the name of the business again?
Sure, absolutely. It's called In the Know Legal.
Oh, okay. I'm just writing that down.
That's
hopefully
no
everybody
problem.
else is.
InTheKnowLegal.com.
Yeah, what? I mean, I love the fact that something that seems so complicated and so scary and just intimidating can be brought to the general public to make it easier to understand and hopefully just a lot less cumbersome. But you did say this kind of first iteration, like early on, it was mostly coaches. Is that what you said earlier?
Yeah,
I wonder.
Our first iteration of agreements are geared towards coaches. That's exactly. So if you were to go to InTheKnowLegal.com, it's like, I have a coaching business, and it's like, are you at launch? Are you at growth? Are you at expansion?
Wow.
Because how are you actually supposed to know what you need for your business, right? So we do that guesswork beforehand. If you're just starting, we're not going to be like, do these 500 million things, do your retreat agreement and do your membership agreement and do your this. And so we try to break it up for them. And it's because we've seen such a growth in the coaching industry. And I know in particular in the health coaching industry, just in the last decade, I feel like it's been just sort of exponential growth. And so for most of our coaches, and tell me if this resonates at all with you, this idea of having contracts is somewhat antagonistic or confrontational. And that's the last thing our coaches want to be with their clients, right? And so we really want to change that narrative and say, actually having an agreement, a client services agreement, we don't have to call it a contract, it demonstrates it to your client that you actually care and that you're setting up boundaries. And that you're showing them, I care about your boundaries, you care about my boundaries. I want to give you the most out of this. So I'm going to tell you everything that I do. And what I do and what I don't do. Super, super important, right? And so it's actually not an antagonistic sort of thing to present them to clients, as it is something to demonstrate a really good relationship between the coach and the client.
Yeah, I love that reframe. Actually, you use the phrase, or I jotted it down when you were kind of telling your origin story, this idea of being empowered in your business. A lot of people, like we kind of joked at the intro, like people are really scared to screw up legally, and they are. There's fear, but
of course.
And then there's this antagonistic thing you're talking about. But the client agreement is the structure, it's the framework. It's I built this thing, I'm the coach for you, and I help you in this way, and here's how our relationship is, and here's what we do, and here's what we don't do. And it's a really empowering document. It's not a scary contract. It's honestly foundational to kind of what you do as a coach.
Yeah, absolutely. And it's really interesting because I always think about this, like coaches are so into taking care of other people. They take care of other people, but like who takes care of our coaches, right? And so it's really interesting. I think most of us can relate to like a relationship. Like you can give and give and give and give to a relationship, but if you completely deplete yourself, at some point there's going to be consequences. You're going to snap, someone's going to regret, someone's going to, whatever. However, if we take care of ourselves in that relationship, we're able to just give a lot better and a lot stronger. And so I feel like it's similar.
Well, just anecdotally, in my, I guess, 7 years of practice, I've had over 1,000 clients. And nobody has ever gotten mad at me and threatened to sue me.
That's
Right.
great.
Right. Which is, I think, what coaches are scared of. And so
Right.
I don't know if that sounds like a wacky place to start, but
No, it's fantastic.
let's talk about what can happen.
Absolutely. Absolutely. So if we think about, if we kind of start from the origins of a practice, right? You know, what you're doing, we don't always want to think of the lawsuit, although that is the worst case scenario, right? We don't want that. We want to sort of think of all the things that can happen prior to that and sort of in the legitimization of our business. So, you know, the first thing we want to do is we want to separate ourselves as a person from our business. That's the first thing. And that's because what can end up happening is the lines are blurred between, you know, Aaron Power and then, you know, Aaron Power Incorporated or Power Incorporated. Yeah, I like that. Power Incorporated.
Power Incorporated.
Let's do that.
I like it.
Let's do that. So Power Incorporated, sorry, I digress. And we want those to be those separate things, right? And what can happen at that stage is that, you know, you have your life as a human, you know, people, your assets, all that sort of stuff. And part of that is your business. And so what we want to do is we want to separate those two. And what can happen in that situation is if we don't, you're leaving yourself vulnerable. Even if there's not even just like a lawsuit, if it's just a matter of a financial issue or you're working with a vendor, or it's a credit card issue or anything like that. And so our motto, and you're going to laugh, is don't settle for half asset protection. And it's basically, we do both the legal and the personal side. So we say, you know what? Take care of yourself personally also within the personal legal side. That is, you know, whether it's sort of just a trust or any of those things, you know, healthcare proxy, things like that, and also take care of the legal. So then what can happen after that? So we separate ourselves. The second thing that we want to do is we want to insure the business. And so this is the way that I think about it. And I think it's very timely. Nobody normal says, I don't care if I get COVID, I have health insurance. Nobody says that, right? What we first do, is we separate ourselves, you know, we stand 6 feet apart. And then in case we get sick, we have insurance. So that's what we do here. Separate ourselves from the business, stand 6 feet apart, and then we insure it. That's just because if anything comes up, it's a pain in the butt. If someone just is like, wait a second, I thought I was supposed to lose, you know, 100 pounds and I lost 10 pounds and this is a problem. The first thing I wanted to do was like, okay, I'm just going to talk to my insurance company. This is going to be a problem client, you know. And then all the stuff that happens before a lawsuit is the stuff that is the most emotionally and physically and mentally draining, is that sort of back and forth quibble about, you promised me this, I thought it was going to be this, you know. It doesn't always result in a suit, but it can result in bad feelings, bad reviews, insecurities, things like that. So because of all that potential for misinterpretation, because you're educating the client, that's where we need the situation of that client agreement. Additionally, what about all of the amazing stuff that you create for your business, right? You create methodologies, you create, ways in which to do things. A lot of these things are created on your own. So not only are you trying to protect that relationship between yourself and the client, but yourself and the world. You know, it's great. Imitation is the best form of flattery, but imitation can also be stealing. And so those are also things that come up. So in an essence, then of course, the worst case scenario, as you had mentioned, is the potential lawsuit. And we're in a very, very litigious society. That's America. And everybody thinks that they're a born lawyer. I have people say I should have gone to law school because I can argue well. I'm like, no. And so that is the worst case scenario. And so always having these 3 seminal protections, which is having that entity, having some kind of insurance that's preventative, and then having this agreement. That's what courts, if you ever have to go to court, will look at. Say, what does the agreement say? What do your protections say? And that's not just about with you and the client, it's with you and a vendor, you and an employee, you and a contractor, you and your fellow coaches. You know, we just want to be like, I want to share with you, but I also don't want to open myself up to liability by sharing. And I also don't want you to take all my great stuff.
Right.
But I often think that 90% of the time, more than 90% of the time, it's not even just the lawsuit, it's the constant sort of misunderstanding, misplaced expectations that we're worried about.
And kind of, it's a great question that you started there, Erin. But my personal thought is the risk of you actually being sued, if you're truly functioning as a coach, is very small.
Yes.
Okay, so let's just set that. I don't even know if you have any line of sight of how many lawsuits there have ever been to health coaches. Do you have any?
Sure. In general, it's going to be pretty low. I would say that it's more in the wedding industry that I've been seeing it, not the coaching industry, but we would say it's probably less than, 2%, because you just don't actually go to court. It's a lot of the stuff that comes before it. It's not, it's all of the just issues that come up in your business that you just don't want to come up, that are sort of eradicated. That's why you have waivers. That's why you have not, these agreements. That's why you have privacy policies, anything on your website that you're selling or doing. Internet's a big thing. That's why we have amendment or even cancellation things. We have things about just respecting each other's time. Listen, if you're not gonna show up or do this or whatever within 24 hours, or if you buy a package from me, or if you buy this course, it's those things. So it's not so much about this being scared of being sued. It's really about, I almost feel like scared of being misunderstood in a certain way, and as an entrepreneur, as a business, because there's you as a person, but you've also created this entire business, sort of this legacy that you're creating. And that's much larger than us as a human. So we want that very tightly knit in all areas.
Yeah.
Well, go ahead, Erin.
We teach, kind of just springboarding off what you were saying, Laura, is like we teach our students, first line of defense is watch your language. What are you saying? What are you saying? What are you shouting into the void on your social feeds and your email list? Like, if you're offering to, I'm going to get 100 pounds off you in 30 days, it's like, I would probably tap the brakes on that. And then of course, there's the scope of practice of like offering to cure disease states, which we strenuously discourage. But even I've seen coaches who are offering really dramatic weight loss or really dramatic health improvement. It's like, you're setting the expectation even before you've gotten into a relationship with this client that you're a miracle worker.
Absolutely. And that's a really big thing, because it's that reliance issue that comes on coaches a lot, right? Like, you rely on your coach for some points. It's like a lot. You're like, I have a coach, they're going to fix my life, versus I have a coach, they're going to teach me. I have a coach, they're going to empower me. And so those are the types of things that you just want to be careful of. And I think you probably teach your clients and coaches this too, just from an integrity standpoint. And that also wants to be clearly delineated on paper, because here's just a little bit of really boring law, but I'll try to make it exciting. Everything that you say prior to giving them a contract is basically void once you give them the contract. Okay. However, number one, you want to be careful about what you say, because you don't want it to sort of like be totally different than the agreement that you give the person. And number two, that agreement, you really want it to be that final expression of your understanding between the client. So hopefully that agreement will be like, while studies have showed that you can have up to this much weight loss, there is no guarantee. And also just things like, and believe it or not, it's like, I have a health coach, so I'm going to become rich because, once I'm healthy, then I'll be smarter, then I'll be richer. And so you literally have to have disclaimers in there about just like, not just about disease and health, but like, I'm not guaranteeing you like a miracle relationship with your spouse. I'm not guaranteeing this, just all of these really interesting things that I've seen come up for my own coaching clients. And that's a big part of my law practice, is coaching clients and talking about all the sort of eventualities and the stories. I love the stories. They're really good.
Yeah, we're big fans of stories too.
I know. I just live vicariously off of other people's stories.
Where I think people get really nervous about this stuff in their own liability is when they come to coaching with a misunderstanding of what coaching really is. We see this all the time, Erin, right? Like, how could I even go to business? Because in my state, I can't give nutrition advice. And we're like, well, that's okay, because that's not coaching.
Right.
It's not coaching.
Right,
okay.
Right.
So let's sort of work around that. If you are focused on the coach approach and you're focused on behavior change, habit change, education, I promise you, your chances of being sued are minute. Like, that's not what you should be worried about. I totally agree with you about your own sort of reputation, how people view you, being misrepresented somehow. And so being very, very clear about what you do and what you don't do is so important. And to Erin's point, a lot of that's just coming with how you present yourself and what's coming out of your mouth and what you're saying. But then the next step is that needs to be, I 100% agree with you, like in writing someplace. You need this client to sign saying that I understand what you do and what you don't do. So do you mind giving us a little bit of like, hey, what should be in your client agreement?
Absolutely. Okay. So what needs to be in your client agreement is sort of upfront, what you want to explain is just sort of that coaching relationship a little bit. And so upfront is that, this is what coaching is. Absolutely. And this is what coaching isn't. You want to have your basic, and I know people are a little bit nervous sometimes about like, do I put my payment stuff up front? You want to put that in there, and you want to talk about, when you talk about rescheduling and payment, you want to talk about communication also. And so those are really three important things. The next thing is, after defining that relationship, it's sort of like, okay, how do you work with me? What do I offer? And so this is one thing that I think is really important that not a lot of people realize, and what can make agreements seem really complicated. What if you offer a lot of different things? What if you offer the membership, the retreat, the courses, the one-on-one? Do you have to have 6 different contracts? Absolutely not. You have one agreement that is the same for everything. And then we have something called a scope of work that we attach to it. That really sort of is then specific about what that client wants. And if there's additional terms that go with that scope of work, we can put it in there. However, we just want that one agreement that applies to everything about rescheduling, everything about, we also want to talk about any sort of refund policies, stuff like that. We also need to have some disclaimers in there, and that they're agreeing to this on their own volition, that they are in charge of their own health, they're in charge of their own wellness, all of that sort of stuff. If we are in group sessions and memberships or retreats, we want to have some really important confidentiality policies, privacy policies. If there's any medical that's going to be discussed, maybe any Hipaa policies, unless, if that's needed. We also want to have, even with our one-on-one clients, we want to have confidentiality policies to say, well, you know what you're telling me doesn't go beyond this. It's different for group, right? It's different for retreats. It's different for membership, and you can't control what those people do. So you basically lay out the guidelines, and you're like, we will and will not tolerate this sort of behavior. We want welcoming environment. We ask that you keep everything confidential, but you are not responsible if Sally goes and talks about Joe and what they're doing. So I think those things are really important, what you can and cannot control. So what you can't control is as important as what you cannot control, and letting them know that. If they're like, Laura, this person said this to me, and you're like, sorry, you won't tolerate it in your group, but what happens outside your group or these sessions is not within your control. So those are things. So expectations, policies, communication, everything about canceling, amending, refunds, payment, that's got to be super clear, right? You don't want to be like, okay, and go down the slippery slope and sort of be like, all right, well, this person said they couldn't make it in 10 minutes, and you can be nicer than your policy, and that will make you look like the hero, but you need to have that policy. It's always like, I charge this much an hour, but for you, I'm going to do this. Like, you're the nicest lawyer ever. I'm like, but it's great to have that, So those are a lot of things that we want in there. The clear definition of the coaching relationship. You don't have to have exact services you're providing them, because that will be in the attached scope of work. Okay. You want to have a very clear, what we call modification clause, that says any changes, might be more money, might require a modification agreement, all of that sort of stuff. And then I'm sure you've seen these in agreements, and you're like, what does this mean? It's like, this agreement's the entire agreement, nothing but the agreement, and and blah, blah, blah. And that just basically says, this is our expression. This is what we've decided on. Everything prior to this, where we went back and forth on email or whatever, this is our final expression.
Okay.
It can change, but this is what we've agreed on.
Okay.
Go ahead.
Well, I just want to know about the language. So can coaches write this in their own language? You know?
Can they write it in their own language? This is a really good question about tone. Yes and no. So one of the things I'll just, talk about in the no legal a little bit in terms of the coaching agreement. So let's say that you were to go onto our site and you're like, I'm starting as a coach. So what do I need? Some basic things, what do I put on my privacy policy, website terms and conditions, and then my coaching agreement. So one of the things that you don't want a coach to do is to take an agreement and just kind of copy and paste it because they don't know what it means. So I think the opposite of that, Erin, is kind of what you're saying is, well, can you write it yourself? Yeah. A lot of it you can, but a lot of it you cannot for the base because of the fact of the ramifications of the language. So one of the things we think is really important for the coach is the very first thing that we usually say is like, what do each of these things mean? Right? What does this hereto, henceforth, whenceforth, which we actually try to keep out of our agreements, mean? Number one, to you, so that you can decide or decide not. And then we actually walk them through all the information they need. And then what's really important is all the optional stuff that's in there. You can put this in your own words. You can write this. If you don't want this, take it out. Teal language is optional. Purple language is fill in the information. So to that extent, Erin, it's not a good idea to write an agreement. However, coaches should absolutely write any policies and procedures that they have. That can be in their own language. That's business practice. That should be completely up to the coach. So that's why another reason why we created something like this is sort of like those people who do want to write their own agreements and customize it. Here you go. Okay. 10th of the price of going to a lawyer. All the instructions to kind of walk you through it, all the things that you basically need, and then you can do the rest.
I love that.
My next question is about HIPAA stuff. I don't know if you can speak to that, but we've spoken to attorneys in the past. It's sort of like health coaches might not need to worry about it. Can you speak to that a little bit?
Yeah. So HIPAA has to do, with our Healthcare Privacy Act, has a lot to do with the collecting of data and data dissemination, right? So if you're collecting any health information and storing it, that's some of the stuff that where HIPAA speaks to. Is this going into a database? Are you sharing this information? Are you storing it for your own use? All of that sort of stuff. And so it's never a bad idea to have a HIPAA clause in an agreement. If you're like, I'm not sure if I sort of fall within this, but that is all about sort of our data and the information that we're taking from our client that may be private and medically related, and how are we storing it and how are we disseminating it and who can hear about it and stuff like that. So if there is any gray area to it, then a very simple HIPAA clause in there, or simply that showing that HIPAA doesn't apply. In most cases, HIPAA probably would not apply. Even if you just because you have an intake form or something like that that gets you information about your client doesn't mean there's a HIPAA issue.
Right. Yeah. Right. Which I think would be the case for most coaches. Exactly. The information is for their own use for that particular relationship. They're not sharing it with anybody.
Absolutely. Which is very different when you go to a doctor and it's like, it's in our system and this doctor can see it and this person can see it and the nurse can see it and all that sort of stuff. That's where we have HIPAA considerations.
Well, and also just in the type of information you're collecting.
Yes.
Like I'm literally asking you, tell me about a day of eating and what time do you typically go to bed?
Absolutely.
Yeah.
Absolutely. That's not necessarily protected health information.
Right.
That's not what we consider protected health information. And really, basically, confidentiality clauses that you have between you and your client sort of kind of take care of a lot of that.
Mm-hmm.
Yeah. I can't speak definitively for every coach, right? I got to be a little lawyerly here and say I can't say for certain that the HIPAA won't apply, but it can be a case-by-case situation. But I think that what lawyers have said to you probably in the past resonate more is that it won't necessarily apply to health coaching.
Right. And I would imagine anybody doing group coaching, if people are freely sharing information to a group.
Yes.
That's kind of a whole different ball game.
Absolutely.
Right?
Absolutely. And that's why you have those sort of things in your agreement. That's like, I'll keep this within the group, but you have to know that you're disseminating this information in there. So privacy is broken, right? And so there's no expectation of privacy in that group setting because you're sharing this information. But all the coach has to say is, and you can, by the way, you can let people know that you are going to share their information anonymously in case studies and all that sort of stuff. One more thing for the purposes of the business, and you probably do this a lot, is having that sort of that media release or testimonial release up front. I think we all forget to kind of do that. And someone's like, "You're the best coach ever." You're like, "Oh, can you please put that in writing?" I think one of the things to kind of get that stuff up right. What if you keep doing things and there's pictures or media releases, testimonials, you want to use photos? Those are really good things to sort of help build up your business.
A media release. Yeah, that's a great idea. Especially if you're asking people for before and after photos, like if you're a weight loss coach, right?
Absolutely. Absolutely. Media releases are fantastic. Even testimonial releases, like, I can use what you're saying, whether, and it doesn't need to be anonymous. Can we use your first name? Can we use your first and last name? Like those types of basic things that you want to get up front as opposed to like an afterthought.
And all of this can be written into the actual client agreement, the one document.
It can be written. Or some people you can have it into the agreement, which we've done. Some people, depending on their profession, like if you're a photographer, you usually have a separate model release or a media release or something to that effect. Or you can have it right into the document, which we've done. So one of the things that I always like to tell coaches is, number one, it depends on where you are in your business. And there's some really just basic things you want if you're beginning, right? And so you want as much as possible in that client agreement, so you don't have to have 10 different things. Yeah. It's only when you are growing and what we call expanding that you may need, like in your retreat agreement, particular language, or in a membership agreement. And that's where we start breaking out into different agreements. But you want as much as possible in that coaching agreement. Such as things like that: confidentiality, privacy, media releases, testimonial releases.
Yeah. Cool. Can you speak to just kind of moving, I think that was a really awesome rundown, by the way, of client agreement. Thank you very much for that.
Sure.
That was awesome. Just flipping to the privacy policy and terms and conditions. So can you explain what those two are? How they differ from each other?
Absolutely. So there's actually three things. There's a privacy policy, a terms and conditions, and a terms of use. And so, but they're a lot of times used interchangeably. So a privacy policy is sort of a necessity for your website. It's basically just saying what you are and are not going to do with people's information that come to your website, and the reason why it's so crucial, especially nowadays with businesses, even if you're not selling anything, let's just suppose that this is just services you're advertising, is because now it's a worldwide issue. You could be coaching people in other countries and other states. And so California, which is, I'm both in Massachusetts and California, I'm bi-coastal, which are like the craziest states law-wise. Okay, just happen to be like the strictest states for everything. And so their privacy policies might be different, right? We have international privacy policies. Do you want that on there? Because you have to have full disclosure on what you are and are not doing. So that's the privacy policy. And then there's two other things. It's what we call the terms and conditions and the terms of use. A terms of use is basically saying what a person can and cannot do on your website, right? This is what they will get. This is what they will not get, what they can and cannot do. So that is common among anybody who has a website. You want a basic privacy policy, you want a terms of use. And when we draft them, like for our company, for all the templates for coaches, when we draft them, we make them as rigorous as possible so that it applies across the board. The terms and conditions, what that is what if you have all these offerings that don't require that one-on-one client agreement negotiation beforehand, as many people do, right? You're offering these retreats, these courses, these online courses, you're offering these things. There's no opportunity for them to sign a contract with you, right? So that's what that is. It's that online contract, right? I agree. And it kind of just tells them it's that contract for the stuff that you are selling on your website. And it's basically a different iteration of that client agreement, not usually as hefty, just the basic things that you have to have. Conspicuousness about what they're basically getting, conspicuousness about refunds, things like that. And that's a terms and conditions. So if you're selling things or collecting money in any way on your site, you want that. Otherwise, if you're not, and your site is just a means for the client to get to you, it's then just a privacy policy and a terms of use.
Okay. So if you have like an ebook that you sell or an e-course or perhaps and there are other, now, what about if you have, because I've seen this on some people's sites where they don't physically sell anything of their own, but they have like affiliate or referral agreements with other companies, and that's on their website.
Yeah. Great point. Because we actually do, in the No Legal does the same thing. We have affiliates who basically we say, you want to show these to your clients or to your coaches or whatever, then you get the money. If you want it, you get an affiliate link. And so we say that you can say that, number one, in your privacy policy, we may have affiliates, or we do have affiliates that we use for this, in your terms and conditions also. And you can basically say, we benefit off of this. Our affiliates have access to your information. You just sort of put it out there. If they don't want that, then they don't have to use your site, right? And so we, ours is a little bit different. We always link to, we have sort of these elite affiliates who are like, I want to be part of this. I want to, I'm a coaching company and I coach other coaches, and I want to be able to offer these to my clients. And so we say, great, doesn't cost anything to be affiliate. You'll get the percentage, and you can put your logo and everything like that on our site. And sort of vice versa if they want to. If they don't have a site that they want to put our stuff, they can use it how they want. But you do want to let that party know and say, we've got affiliates. They have access to this.
Yeah, I've seen that on other or people when they're promoting something, stating expressly whether they are or are not earning income from this recommendation.
Absolutely.
I think you need to be pretty transparent.
You have to be very transparent. Absolutely. And sorry, go ahead, Erin.
No, I'm just saying that's an integrity move.
That is absolutely an integrity move. And it's interesting how different people do use affiliates and things like that. I think one of the things that we do is we say, we're lawyers, and not a lot of people want to talk to us. So if people are, have coaching agreements or coaches or whatever, they're going to listen to their fellow coaches and their fellow people. So if they're like, hey, I like this, I like this agreement, we always give our affiliates, like, pick whatever agreement you want. If they're like, yeah, no thanks, then don't be an affiliate. If they're like, yes, I want to do this, I want to tell other people about this, it's much stronger than I feel like coming from a lawyer sometimes. If you're like, yeah, I understand this, I like this, I use it for my business. And go ahead.
I was going to ask, just for clarification, is it any different if this is more of like a multi-level marketing company? Because we have some coaches that are really embroiled in essential oils, or Beauty Counters one, or what are some of those other sort of healthy, I'm trying to think of the name.
Yeah. I think I don't know, supplement companies or
Advocare is another one that pops up. Yeah. Stuff like that. Is that any different from the standpoint of, well, it might be different because that's an entirely different company and maybe you wouldn't have that on your website, but
Right. And there are a lot of, I know this, I have, entrepreneurs who are, even, I can't remember the name of it, of this, it's a cosmetic or skincare, but they also do like health and stuff. I should know these things, but I don't. Yes, if they are selling things or have links to those sites, their MLM sites, that will be on there and it'll probably be disclosed, because the MLM companies have those regulations about, it takes them to the Mary Kay site, it takes them to the
Arbonne.
Arbonne,
that's
Beauty
what I was thinking
Counter.
Of. Okay, Arbonne, Beauty Counter. I think
that's another one.
All of those. Arbonne is the one I was thinking of that also has like your health stuff. So that is, and so I know a lot of different people who have their own companies, right? But then also like to sell these items from these other companies. So that is different, because that is sort of an MLM situation. And interestingly, having an affiliate, and we were joking about this amongst each other. We're like, I'm like, are affiliates MLMs? And we're like, no, wait, we're not asking anyone to build a team. We don't want any of that. We're just like, if you want to do it, do it. If you don't want to do it, don't do it. They would probably want to disclose to their own people how to do it. Like, I am, by the way, earning money from here. As you had said, Erin, that's more of an integrity issue, right? And I always say to some people, like, hey, I'm in a 10% partnership with this person, or hey, you know what? I'm not getting anything. I just really like this stuff. My own health coach, who also happens to be my neighbor, he was saying that about, I was tired of walking by and him being like, so when are we going to do some training? And so I'm like, finally, yes. No, he's fantastic. And he's a professor of exercise science and nutrition out here in California. And so he'll say that. He goes, these are supplements. By the way, I don't get anything from them, or yes, I have an interest in this. So those things are always good to do.
Yeah, this is great. Thanks so much information.
Absolutely.
I want to circle back to online courses.
Sure.
So my understanding from what you shared is, as long as we have the terms and conditions on our website. So if I have on my website, click here, enroll on my course. I don't have to have anything in the course. So like it's on my website, it's covering all of my digital courses.
Right. So what do you mean you don't have to have anything in the course?
Well, like sometimes I would have a chapter in my course is kind of like sort of the agreement. Like, I don't know. But I guess I don't need that necessarily. Like it links out to a hello sign. But these are just digital courses that people go through at their own pace. I'm not coaching them. Am I like that overkill?
So this is the thing. Sometimes I like to disseminate information in different ways. And so this is sort of a yes and no question. So if you think about the different learning styles, there's the audio visual, there's a read write, kinesthetic, all that sort of stuff. So that's what we sort of cater to. We're like, hey, don't copy our stuff. And then, or don't disseminate this. But then also in our videos, we're like, hey, sharing is caring, but sharing is also stealing, and so, we do it. I mean, I probably even do it in that sing-songy voice, which is terrible, but we do that just because if they haven't read that thing. But if you feel like I don't really need this because I have a terms and conditions that they have to click agree, then no, there's no reason to. You can have some basic things in there that you really just want to sort of hone in on,
right.
Don't, by the way, just so you remember, don't use this, do this at your own peril, stuff like that. And so I wouldn't, like, we have our disclaimer, let's say at the bottom, like, don't steal our stuff. And I'm not going to read that on my video. I'll just kind of put it in my own little, like, nice, friendly tone. So yeah, you don't need to. If you have that information conspicuous in one place, then that's just a matter of your comfort.
Yeah.
Yeah. I tend to disseminate I'm a full-time law professor here. And it's interesting because one of the things I've learned is that these students can be equally as intelligent as one another, but just learn and absorb information totally differently. So sometimes I'll present it in different ways, but you don't have to overkill, liability stuff. You don't want to necessarily throw that in their face where then they're like, I'm scared.
Right. They're going to be like, maybe I shouldn't have bought this. Speaking of liability, that was going to be my next question. So is the client agreement, is there a liability waiver in there, or should it be a separate document?
You can do absolutely both. My thing about the health coaching industry in particular is that sometimes it's nice to have a separate liability waiver. You don't have to. You can literally have all the waivers within that agreement. If there's something in specific that you're like, I really need them to disclaim anything health related to this, you can have a separate one. Just like I say, my photographer should probably have a separate media release. However, I do think that can be in the agreement. The time where I think it's really important is if you're doing any sort of, especially now during the pandemic, one of the things we created is this COVID liability waiver. And it's a health and COVID liability waiver and indemnification agreement, which is basically like, listen, you're representing, I'm doing everything I can, you're doing everything you can. If you get COVID, it's not my issue. Things like that. That's for the really in-person, that sort of stuff. That is more important, right? When you're going to one-on-one, that person's, coaching you and doing all that sort of stuff and adjusting you, I would say it's important to have a separate one. When you're doing other stuff, then no.
Yeah, because one area where I think it might be important to just make sure it's detailed is for folks that are dealing in fitness and they're training people where they could legitimately get hurt.
Absolutely.
Yeah,
absolutely. I think I signed one for Jeff as well. It had everything. It was in his intake with his agreement, with the liability waiver. And I think that was good because honestly, and this is where it's really tricky with the law, ignorance is not an excuse. So when a client's like, I just didn't read that contract, right? That's not usually an excuse. When something is so germane to your practice, such as working with fitness or working with people, you want to be as conspicuous as possible. And so what courts say is that you can have it in that agreement. It should be all caps, or you can have just that separate liability waiver form. And so we do that when we're going through our videos. I'm like, do not uncap the caps. I'm like, they're there for a reason. It wasn't a typo. It wasn't a mistake, because courts are all about being conspicuous.
Right.
And the law is. And so it used to be, you can kind of tuck that in there. So that's a matter of comfort. It will be effective either way. It's just a matter of like, I really want you to know that this is being waived. Otherwise, that agreement is all encompassing. So you can do both. And we always tell that to people. We're like, listen, there's all these disclaimers and liability waivers. You expressly waive any implied or express liability in there. If they're like, listen, I'm having situations where I'm dealing with COVID or, injuries or this and that, there's also another waiver that they can grab.
Wow. It's so crazy that all caps makes a difference. And like,
it does. It's all caps. And I have to be like, don't uncap that, I know it seems like we're yelling, but we kind of are.
We are. It is legal yelling.
It's legally yelling.
Okay. How in your opinion, like how international, everything we've talked about here, because not everybody listening is in the US.
Right.
So like, to me, these just sound like good practices that any small business owner should be embarking on. Would you say that that's probably relatively accurate? So
yes. So, when it comes to contract, if we think about, this is where it gets really interesting with the law. So technically, we're with the in the know legal, for example, in my law practice, I'm practicing law and I can only practice in certain states. Right. That's it. So even if someone from New York was like, hey, can you look at my contract? Technically, I can't, even though I'm like, a contract is a contract. Within the know legal, we're not practicing law. What we're doing is we're basically saying, this is common, what we call like common law, common to what we generally learn in law school and what we know about contract law. Your state or your country may have specifics. So one of the things we always say is like, you might want to have an attorney look at this. And I'm like, okay, then why would I go to you? It's because to have an attorney glance at something, to be like, okay, just throw in laws according to Massachusetts and this one little tweak, then to have an attorney create something from scratch is just going to be vastly different. Right. So we always say, you know what? Yes, there are general contracts out there, but the ones that sort of explain it to you and kind of walk you through, we'll always say, you know what? If you're concerned and if you think there are differences where you are, you can always ask somebody about this. Generally speaking, it is general contract law. It's just that certain states might have more stringent requirements.
Okay.
Are there any particular states? Well, you just mentioned California and Massachusetts, but any other states people listening might be like, you know what, if I'm going to use a template, because my state tends to be stricter, any guidance there on, hey, if you're listening from Florida, you're listening from wherever.
Absolutely. I joke about, the reason I also joke about California and Massachusetts is their independent contractor law and their employee laws. If coaches are employing somebody or using an independent contractor in Massachusetts and California, it's almost impossible to be an independent contractor. It's very difficult. So those are one of the things where they would say, okay, I'm hiring people. I might want to chat with an employment attorney. In other situations, a business attorney in that state, right, where they're just sort of like, I think there are certain things around the healthcare industry, in our privacy laws that are necessary, which is why one of the things that we say with our agreements is we just write them to the strictest states that we know. And then so that it might hopefully take it, but we don't know every state's laws, but we just try to like, what do we know is the craziest? We're going to write it to that standard. But I always say, since we're not their lawyers, we are lawyers, but we're not their lawyers. They want to check just to say, what are the things that could come up? There are some things in certain, that I say mostly have to do with having employees or contractors. Non-competitions have virtually been, non-competes have been eliminated in like Massachusetts and California.
Mhm.
Privacy laws are huge, so we write them, whether you're an independent contractor or an employee. Other than that, with clients, that is just more like, hey, is there something really unique I have to do? Is there something in our state about this that I have to know? I operate my businesses in California and Massachusetts where they're headquarters. And yes, I have to do different things with California, like pay way more taxes than in Massachusetts. And my reporting is different and stuff like that. So those are types of things that I'll say, even though I'm a lawyer, I'll chat with the business lawyer friend of mine who's still going to charge me, of course, and ask them, what in particular do I need to do here?
Yeah. And I can see that because there are some people that might live and practice mostly in one state, but are close to the border of another state that you might want to just be aware of.
Yeah. And that brings up another issue about where are you considered legally sort of present, right?
Yeah.
Where are you incorporated, things like that. And I think what's really important for your coaches to know is that there's always sort of this tax thing and then there's a legal thing, but they're not the same, right? So if you're picking a business entity and you're like, my CPA told me to do this, your CPA told you to do this because of the tax protections. What does your lawyer say? And so we want to consider those things. It's really hard with online businesses, and the law is so archaic that it takes a while to catch up with the fact that sometimes we just don't have a location. Our location is the World Wide Web. And so those are other things that people want to take into consideration, is where are they considered to practice? And I would say that your regular thing is what we call the nerve center. Where is your nerve center? Where are you located? Where are the owners and operators and stuff located? And let's do that. If you feel like a substantial amount of your business is in one other particular state, then you might have to incorporate there. Otherwise, you're probably good in that one particular state. But you're absolutely right. For me, I think my predominant, like where I'm headquartered, is Massachusetts and California. However, where I do business for some of my other companies is just all over the place.
Yeah. Right. And so we think about the regionality of legal language. If I'm here and my clients are literally all over the world, am I writing my legal documents in reference to where I am? Yes.
Okay. Because what we can do is we can pick, it's called choice of law. We can say, the laws of California apply. The laws of Florida apply. And the Supreme Court has recently said, yeah, we're going to uphold those, right? Because, it used to be that you would write a choice of law. You'd be like, we're doing it according to Delaware. But the plaintiff and defendant are in like Kansas and Mississippi. And then Mississippi's like, no, we're striking that down. But now courts are like, listen, if they've negotiated this contract and this is where the choice that they've decided, and this was just recently, actually in the last 5 to 6 years, Supreme Court's like, we're gonna allow that. We're gonna let them choose where the law is, right? It's in the absence of choosing that we have default rules about where the law is applied, right? But other than that, you choose, right? Your state, or you live in your state, so you want everything to be applicable in that situation.
Okay, that makes sense. Man, so many good questions. You're answering so many good questions.
I might be answering questions that you're also not asking, because I tend to do that. So you can reel me back in.
I had another question about this like liability waiver, and just how enforceable is it relative to insurance, right? So you're getting people, and is that determined by state? Like if there's a legal, like legit liability waiver and someone's like, you are held harmless, just how enforceable typically is that before somebody can try to sue you?
That's a really fantastic question. I don't know if you've ever done anything, like go on a cruise and you do something like dangerous and they're like, you die, even if we run over you with the boat, we're not liable, right? There's those things. And so what we say is that we don't want to tell, it's what we call the adhesion contract. And that means that it's not something that if it's not changeable and you can't discuss with somebody, we want to be careful what we put in there. So essentially we say this, and there's a lot of stuff. We want that liability waiver to be enforceable. So courts will look at the fact that they're enforceable. What they cannot be is what we call unconscionable. Unconscionable meaning like if we do something horrible to you, we're not liable. However, does that mean you can't put that in there? No, it just means that part may not be enforceable. Right. So if you're like, you disclaim me, even if I'm grossly negligent, we might have issues with the client, number one, signing it, and number two, just that part being enforceable, right? But other than that, we assume equal bargaining power between the two people, the client and the coach, and we want to uphold these liability waivers. A lot of, and I talk about cruises because all the cases I would read in law school happen to be with these cruises. It would be like, you're about to go skydiving or parasailing, they're like, here. And they're like, oh, okay, well, I can't, there's nothing I can do about it or something like that. Or all these things. And they considered it adhesion because it's like there was just no opportunity for the other person to back out. With liability waivers, you can choose to sign it or not to sign it. If you're on a boat in the middle of the ocean, what are they going to do? Throw you overboard? Like, what are you supposed to do? So.
Okay, so the relationship between the liability waiver and liability insurance is...
What's that relationship? Sure. With any sort of liability insurance and malpractice, they first want to see what best practices you have, right? So let's say you go to an insurance company and just like I go to for my malpractice insurance. And one of the things that they'll ask me is, do you have a way of keeping track of billing? Do you have a way of keeping track of dates? Do you have a client agreement? Do you have things like this? So they want to make sure that you have your basic practices in case. So let's have a liability waiver, but then there are those clients who are going to make problems anyway. And it's always well, I just didn't read it, or I just thought I had to sign it, or whatever. You don't have to do anything, right? You can choose not to work with you. So it's in those situations where there is an element where you think a client's like, my lawyer said that this is not enforceable, where you go to your insurance company and you say, I think I have an issue. You want to have liability insurance, or what we call errors and omissions, or anything to that effect, especially I think in the health coaching industry. It's not required for something like in the legal industry or the medical industry, but I highly recommend it. Like, I couldn't practice law in Massachusetts without liability insurance. In California, I guess you don't have to have malpractice insurance, but in Massachusetts, I do. And so when you are filling out that insurance application, they just want to make sure, are you kind of doing your due diligence in informing the client? But when else fails and your client's just like, no, then they go to the insurance company. Because as my clients have always said to me, I have a fantastic contract in place, so they can't do anything. I'm like, they can kind of do whatever they want. They can kind of, remember, you can just keep pointing to a contract and they'll still come back and come back and come back. And that's just a headache. And I'm dealing that with right now in the wedding industry, with everybody, having to cancel because of COVID and stuff. Yeah. And I think brides sometimes, they can be a little bit emotional, and so are the fiancés, just so do the guys, let me tell you, dealing with one of the husbands. And it's just, do what's right over and over and over. And I said to my client, I'm like, you do not want to pay me like the amount of, you cannot argue with people who are emotional about their weddings and stuff like that. You need to figure out a different way. You need to either say, okay, I will sometimes it's just, I will just give you back your money. I will give you back half. And here's another little trick. If you have a disagreement with the client, can't believe I've been saving this. If you have a disagreement with the client and they're like, I'm going to go all over Yelp, I'm going to go over whatever. Okay, sure. I'm going to give you, in exchange for me giving you half your money back, which, by the way, I don't think I owe you, you're just going to sign a simple non-disparagement clause. Which is just to consider, basically saying, sure, I don't know you. That's what a settlement is essentially, but just in nicer terms. If there's a disagreement, I would say the best thing, because instead of running to a lawyer or trying to set your contract, if it's possible, if this person is problematic, to say, you know what, if you can work it out in this non-legal way, say, my clause says this. However, I certainly understand. I don't want you to be unhappy. We can certainly, I'll certainly process, in exchange for, just signing this simple agreement. And so that's another way that we can be harmonious and make sure that angry clients are satisfied and also not tormenting you.
Yeah. Cool.
Sorry.
Yeah. I don't know. I'm just thinking, this is so wonderful. I really appreciate you sharing this knowledge. I think it'd be worthwhile to start, shifting to how you work with coaches. So what kind of services you offer?
Absolutely. So in my practice, a lot of times what I do is when coaches, as a business attorney, when coaches come to me, the first thing I ask them is I'm a client and I come like, what happens? How do I reach out to you? And so I have them take me through the entire process from beginning to signing to even to end. And then I want some worst case stories. I want some best case stories. I want all those sorts of things. So you kind of can think of me as your sort of primary care doctor for the business, right? And you say, all right, what is it that I need? If it's just at the very outset and it's like, you know, I'm a sole proprietor, do I need to incorporate? You don't always have to, really. If this is not your business, or if it's just a hobby or whatever, it really depends. So the way I work with them is actually from sort of, it can be very just particular issues that they're having, but I normally try to do it holistically. I'll be like, sure, I will definitely just look at your particular issue. Do you mind if we just kind of talk about how your entire business is run, right? It's like the specialist who treats the problem, and then it's the person who looks at the whole body, right? And so that's what I really like to do. And then I will always figure out what their intent is. I know like people say, you know, treat others the way you want to be treated. No, I think you need to treat others the way they want to be treated. And so you just kind of figure out what are their pain points? What are some of the issues? Are they really like, I don't know anything? Or they're like, listen, because what if they're like a really educated coach and they've done this and like, this is all I need questions for? If they're just like, I don't know anything, can you just tell me? I think it's really important not to take advantage of the client and perhaps their lack of knowledge. I think it needs to be that you do everything possible to educate that client so they don't need to actually keep coming back to you. My best clients are the ones that don't need to come back to me, you know? So I will do that. So I will look at anything that they have or don't have, and we can go through suggestions, but you have to give options. You can never say you have to have this or else you suck as an entrepreneur, because that is just not a correct answer. It's not. You should really have this, and I'll tell you why, but you need to make an informed decision. Okay. Another way that I think it's difficult sometimes with attorneys and clients, but super important, is to figure out the tone of the business. If you are about, you know, energy and sharing what you love and doing all this sort of stuff, we're not going to have a scary, you know, agreement that talks about all this sort of stuff and that just puts this wedge between the two. So you've got to really, really understand what the tone is. So the pain point, the tone, and then, like I said, I would just walk with them from beginning to end. Now, when clients come to me, I have to be very particular because I can only practice in a certain state, which is why sort of we created this alternate company, the In the Know Legal, so that they could emulate the process of going to an attorney, but go to this, and any coach can go and say, I don't know what I don't know. So let's emulate that process. So I try as hard to do that, like the walking the coach, where are you in your business? What do you need? What don't you need? We tried to take that and kind of create the legal tech surrounding it to do that for our coaches, so that any coach anywhere could do it, as opposed to just those where I practice.
Yeah. So they go to In the Know Legal.
InTheKnowLegal.com.
And is there some sort of like questionnaire they fill out to help determine what they need?
There's a chart, right?
Okay.
And it's like, my biz is this. I am here. I am there. This is who I am. This is where I am in my business, and things like that. Because sometimes what we found with the questionnaires is that there are some basic questions or some basic things that all coaches need. So depending on where they are in their business, we'll tailor it to that. Absolutely. And it's like, you may need this, you may not need this. So it's a clear chart that it's just sort of like, this is where I am. Then when they click on that archetype, right, of who they are, then it will say, this is what each thing is, and this is what each thing does. You can get a package, but you don't have to at all. Packages are great if you're like, I just want this package to help start my business. But if I just really am just looking for a privacy policy, then they can go hone in right on what it is that they want. So it will give them all the guesswork out of it. Yeah. In the beginning. And so that's why I really wanted to emulate that part of working with them. And then, of course, the stuff about, we have a lot of our entrepreneurs who are sort of like, I've got a great business, but I don't have any of my other legal protections in place. We kind of talk a little bit about in there so they can make a choice of, I want to do all of this now. I want to do some of this. I only want to do one of the things, or I want to do none of it.
Yeah.
We do a lot. Go ahead. Sorry.
I'm looking at your packages here on the website there, and they're awesome, like really robust, reasonably priced.
Thank you.
Yeah.
Thank you. And we try to do, I was going to look at the website. I'm like, what do I have?
No, it's
great. I looked at my website beforehand.
A couple of years ago, I had gone to a lawyer and just a local one here in town. And not that she doesn't specialize in small business per se. She didn't specialize in coaching. And so I was like, I need all this stuff done. Can you do it for me? And it was going to be multiple times more this. And she doesn't even really specialize in what I do. So there's something nice about having that specialty. And it's very reasonably priced.
Absolutely. And it is multiple times when you go to, and I tell this to my clients now, my coaching clients, I'm like, listen, I will be very upfront. I'm like, this is what it is to me. And if this is what it is, if you go to in the no legal, I will leave this choice up to you. Because some people are like, yeah, I just want you to just work with me. It's a very specific thing. I want you to do these, but I'll say, or you can mix and match. And I'm very upfront with them because this is not, in either way, the client's benefiting and we're benefiting too, I can't take on all the clients. I'm one person. So to have something like this is great for not just the client, but also for me and my business partners. Yeah. And one other thing that we offer a lot of just free stuff too, checklists, everything, because I think one of the things is like, how are you supposed to know what it is you're supposed to do? So that shouldn't be something that you pay for. So, all right, legally protecting your business from an intellectual property, startups. What do you need to do if you LLC yourself? You just go and register on LegalZoom and you do an LLC, you don't go to an attorney. Okay, what do you have to do now? All of those things. And then we also have, we're creating an ebook that's just going to be free for the entrepreneur, for the coach. And so we're doing things like that just to get sort of people first, again, as that word, sort of empowered in what it is that they need and don't need.
Wonderful. Cool.
I love it. Wow, we covered a lot of ground here. And thank you for breaking all that down. I mean, look, if this is a topic that I think a lot of people who are initially drawn to health coaching, so it's legal and finance. Those are the two things that like everybody just sort of wants to hide from because they seem complicated. They seem overwhelming and scary. But once they're taken care of, you just feel so much more secure and you feel so good. Yes. Yeah. Right. Absolutely. And so for a few $100s, if you can buy what you need to get started and get it done, it's so worth it.
And if you can understand it too, because one of the things if a client's like, what does this mean? You never want to just be like, I don't know, my lawyer wrote it, or I don't know.
Right.
So that's why we really try to break down. And I think that's where we're sort of being a law professor and doing this for me is the perfect combination because I'm teaching students who don't know anything about the law. So we do the same thing here. We're like, okay, how do we take these complex things and just say, this is exactly what they mean? And in lawyers, a lot of times we can get in our own legal heads and there's this knowledge wall. And again, I probably, like you see with medicine, law is very archaic. Yeah. And so it's like, there's a knowledge wall. It's like, oh no, I'm keeping this knowledge to myself. And if you want it, you have to pay for it. And I'm going to make it as complicated as possible. And it's just not how we need to be doing business as entrepreneurs.
Yeah. Oh, well, we're so grateful that you're bridging that for us. It's really wonderful conversation, Tania.
Thank you.
I know we're going to get a lot of folks who are eager to scoop up some of your services because it is it's like to Laura's point, we get asked this question all the time.
Of course.
Yeah.
That's it's a normal thing. And it's funny, as I started doing more coaching and often health coach podcasts, I told my health coach, I'm like, I need to start coming to you because I need to sort of like, if I'm going to be on these podcasts, I also have to be doing some stuff. I need to be like working out and being healthy.
Yeah.
And it's really hard.
Well, at least you have a coach.
That's right. And to us, the law is hard, right? So it's just depends on your expertise.
What you do is harder. Please. Just trust me. I was talking to my sister on the phone. I'm like, I think I'm emotionally and mentally and physically exhausted. She's like, yep, then it's working.
Oh my gosh. I just love that. And I love that because look, I mean, I think, you know what I feel from you is I feel as though you understand what it's like to be in a startup shoes. You know, most people coming to health coaching are starting from another place and, you know, it's a little scary. It's a little overwhelming, you know, and unless you're in, you know, a unique circumstance, for the most part, money's limited, but this is important stuff. So I love the fact that you've found a way to make this easier, make it affordable so that people can protect both their business and themselves in a way that's easy. And so I just love that. I feel like it's support, that you're providing support. And in this, and at the same time, started a nice little business for yourself, which is something that we tell health coaches all the time that are, you know, we have people that come to health coaching almost embarrassed that they charge people money to do this. You know, this is a business.
Yeah.
Yeah. You know, there's nothing wrong with doing what you love and doing something that you're good at and earning a good living doing it.
Absolutely.
Find the problem, have the solution, boom, you've got a business. Yes,
so. Exactly. I completely agree. Yeah.
I love it. Okay. So inthenowlegal.com is where people should go.
Absolutely.
Cool.
And if they have any questions, they can just email info@inthenowlegal.com because we like learning things from our clients all the time. Again, we're lawyers, we're a little bit limited. And so it's always nice to know some things that they want, you know, that we may not have covered and stuff like that. And then if anybody wants to be affiliate, they can just be an affiliate too. You know?
Love it.
Yeah.
Awesome. All right, Tania, thank you so much for your time. This was really fantastic.
Thank you for having me. I really, really appreciate it. I had such a nice time.
Oh, we've enjoyed it. Who knew we'd be talking about the law and like enjoying every minute.
It's very rare.
All right. Thank you.
This podcast was brought to you by Primal Health Coach Institute. To learn more about how to become a successful health coach, get in touch with us by visiting primalhealthcoach.com/call. Or if you're already a successful health coach, practitioner, influencer, or thought leader with a thriving business and an interesting story, we'd love to hear from you. Connect with us at hello@primalhealthcoach.com and let us know why we need to interview you for Health Coach Radio. Thanks for listening.
Well, if you've been listening at Health Coach Radio, you'll know that we're all about raising the voices of practicing health, fitness, and nutrition coaches, but most importantly, helping to further legitimize this exploding industry. Erin and I have disclosed often that we're on the faculty of the Primal Health Coach Institute, founded by none other than the health and wellness legend Mark Sisson. And we've interviewed dozens of guests from just about every different health coaching program you can think of, and who practice in just about any conceivable way you can think of. But our allegiance is to the health coaching industry in its totality, first and foremost. It's our desire to continuously and unapologetically lift and promote this industry that nudged us to create this podcast for you in the first place. It's this same yearning that encouraged us to take the educational offering at our health coaching school to the next level. We are so proud to offer the Primal Health Coach Level 2 certification course, which when combined with our primary course, the Primal Health Coach certification course, not only satisfies the educational requirements to sit for the board exam, but is specifically designed to teach advanced coaching mastery. You will work closely with a small class of peers through this 12-week, very intensive, live online classroom experience to learn how to execute a coaching relationship that is truly transformational. You'll learn and practice how to ask powerful questions, what it means to hold space for your clients, but most importantly, how to actually do it. You'll learn about the craft of motivational interviewing and the nuances of habit change, goal setting, and accountability, and how to nurture your client's own inner knowing, their intuition, and their own self-efficacy, so that they will graduate from your care a truly transformed person. You want a big, successful, powerful coaching practice. And maybe you're devouring our episodes looking for the silver bullet that's going to launch your business into the upper echelons. We've said it a million times and we'll say it again. Your coaching skills are what will make or break you and set you apart for success in this field. So if you're looking to level up your coaching skills and maybe dial up your credential and become a board-eligible health coach, look no further. You can learn more about PHCI's Level 2 program at primalhealthcoach.com/level 2. But if you would value talking to a real person about your path to being a masterful coach and perhaps a board certified coach, book some time with me personally. You can access my calendar at primalhealthcoach.com/call. Or just call me. You can reach me at 844-307-7662. Thank you for listening to Health Coach Radio, and I hope I get to talk to you soon.